Hello, everyone. Thank you for attending today's webinar. Good afternoon. My name is Trey Cleveland, and welcome to Thompson Coburn's second edition of the Higher Education Roundtable. The Roundtable plans to cover a topic every quarter that affects litigation within higher education. Last quarter, we covered the overturning of the Chevron doctrine and the newly decided Loper-Bright decision. This quarter, we will detail some upcoming and already existing rules regarding the Telephone Consumer Protection Act. Hopefully, this webinar will allow your institution to avoid litigation. However, before we begin, we have a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these questions during the webcast, but if a more complete answer is needed or we run out of time, we will answer it via an email at a later time. A copy of today's slide deck is available in the resource widget, and we encourage you to download the resources or links that you may find helpful. Additionally, we will share our contact information, myself and Brant Hill, the other presenter, and you can email either one of us and we can send you the slide deck directly. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. Today's presentation is CLA accredited in California, Illinois, Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transactional lawyers. We award CLE based on attendance for the entire 60 minutes. We will display secret words in 2 multiple choice polls during the presentation, and you will be required to select the secret words from a multiple list choice. Please respond to these polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in this course. With that, we will begin our roundtable on the Telephone Consumer Protection Act and new FCC and FTC rules. First, a bit about myself and my co-presenter, Brant Hill. We are both partners at the Thompson Coburn firm. We are a full-service law firm with over 400 attorneys. We have offices in Chicago, Los Angeles, St. Louis, Dallas, New York, Birmingham, and Washington, D.C. Our higher education practice provides legal counsel, compliance, policy, training services to colleges and universities. Again, my name is Trey Cleveland. I'm the co-chair of our higher education practice group, and I am a litigator by trade, and I represent institutions all across the country in a variety of different types of litigation. Our practice group has over 20 full-time practitioners that focus on a litany of situations that could affect higher education institutions. We focus on regulatory, compliance, operations, litigation, risk management, corporate compliance, mergers and acquisitions, government relation, and lobbying at the federal level. My co-presenter, who is my partner and my friend, Brant Hill, also is a higher education litigator. He routinely works within the TCPA in cases, and he has provided a lot of guidance and policies for institutions in their TCPA compliance. I would not be a good lawyer if I didn't give you a disclaimer so that you can not rely on anything that I tell you. And I am required to read this verbatim. Please note that the purpose of this presentation is to provide news and information on legal issues, and all content provided is for informational purposes only and should not be considered legal advice. The transmission of information from this presentation does not establish an attorney-client relationship with the participant. The participant should not act on the information contained in this presentation or any accompanying materials without first consulting legal counsel. If you desire legal advice for a particular situation, you should consult an attorney. And we would gladly like to be your attorneys. If you need such services, glad to help any of you in any way possible. We've presented a syllabus like a good instructor would do in a higher education seminar. Today, we're going to talk about the Telephone Consumer Protection Act. Brant will begin the discussion. And in the first part, he will get into details regarding what is required for express written consent under the TCPA. That is of the utmost importance. I will say that when the topics that Brant will cover today are for the institutions that do a lot of their marketing directly. And then the two areas that I'm going to cover are for all institutions, whether they do their marketing directly or they use third-party vendors. So after Brant gives a good overview of the TCPA and the consent requirements, I'm going to talk about the new FCC rule, which is the one-on-one consent rule. It becomes effective on January 27th, so very soon. If you're not aware of this rule or not aware of the implications it could have, it will be very, very important to understand it. Brant will then discuss the new revocation of consent rules, how students can revoke their consent to receive marketing and other information. And then I'll talk about the new record-keeping requirements. And some of those are a bit of a change of what is currently, or what was previously required. And with that, I will hand it over to Brant.
Thank you, Trey, and good afternoon, folks. Once again, my name is Brant Hill, and thank you for joining us here today. Just jumping right into it, telemarketing activity in the United States is governed by a variety of different laws and regulations. And at the federal level, the primary law, of course, is the Telephone Consumer Protection Act, which is enforced by the FCC. The TCPA is focused on unsolicited faxes and telephone calls. But the Federal Trade Commission, through its Telemarketing Sales Rule, also regulates telephone calls. Because why just have one federal agency oversee you when you can have two, right? But the FCC and the FTC's regulations pertaining to telemarketing do overlap in some areas. And as we'll talk about today, one of those areas is the National Do Not Call Registry regulations. But the TCPA is really the big one here because it authorizes a private individual to sue and recover penalties for an unlimited amount without any showing of actual harm to the consumer plaintiff. Whereas the FTC is generally only enforced by the agency itself or by state attorney generals. And it only allows a private plaintiff suit if the consumer plaintiff has suffered over $50,000 in actual damages, which is pretty exceptional and rarely occurs. Now, very importantly, the TCPA does not preempt state telemarketing laws. And there are several states out there that do regulate telemarketing. And in some instances, those state requirements are stricter than the TCPA requirements. These laws are commonly referred to as mini TCPA laws. We're focusing on the federal laws and regulations here today. But tracking those state laws and their requirements is very challenging, it's tedious, and I would highly advise anyone listening that is operating in a particular state or is communicating with consumers in certain states to confer with your counsel, check those state laws, particularly regarding issues concerning the days of the week that consumers can be called, the hours during which you can call them, and the frequency with which you can call them, as each state is a little bit different in these areas. Finally, marketing and commercial emails are regulated by the Can-Spam Act, which is also enforced by the FTC. We'll touch on that briefly today, but really we're focusing on telephone calls. So the TCPA, it's a 1991 federal law enforced by the FCC. And again, it's the primary federal telemarketing law in the United States. And at a high level, the TCPA regulates telephone and fax communications. Believe it or not, there's still a lot of fax communication cases that are being issued out there today. But today we're really going to be focusing on telephone communications. And by that, I mean telephone calls that are placed to both residential landline numbers and cell phone numbers in the United States. And importantly, when I refer to a call, I'm referring not only to your standard voice call, but also to a text message. So keep that in mind when we're talking about a call today. When you see on the slide, there's a reference to a call. We're generally also talking about text messages. So TCPA regulates phone calls and texts sent to a residential landline number or a cell phone number. And more specifically, it primarily applies to phone calls that are placed using certain types of automated or regulated technology. One of those technologies is an automatic telephone dialing system, or an auto dial. In just a minute, I'm going to talk about what an auto dial means. The other technology is an artificial pre-recorded voice. We'll talk about that too. And if you're using either an auto dialer or an artificial or pre-recorded voice on a call, then you need to first collect the call recipient's prior consent to make that call. What does prior consent mean? Well, it depends on the nature and the purpose of the communication. If the call is for marketing purposes, then you have prior express written consent. If the call or text is for informational purposes, then you only need to have prior express consent. The difference between prior express written consent and prior express consent is a very significant one, and we're going to dive into that. And then finally, if the call uses automated technology and it's for an emergency purpose, you don't need any consent at all. Now, the TCPA is a very punitive statute. It imposes $500 penalty per unlawful call or text. And as I mentioned, it allows a private individual to seek relief on behalf of a class without any showing of actual harm they suffered as a result of call or text. There is no cap on damages, and there is a 4-year statute of limitations. And so if you are doing telemarketing, a lot of it, you're placing a lot of calls, you can see how the numbers can quickly add up. And if you are not strictly complying with TCPA, you can easily be hit with a 7- or 8-figure monetary judgment. The plaintiff's bar loves the TCPA. The statute has been called the poster child for lawsuit abuse by the former FCC chairman. And the TCPA has bankrupted hundreds of businesses, some of whom were not bad actors or scammers and honestly thought they were complying with the law. But there are no good faith exceptions to the statute's requirements. It is a consumer protection statute, and it requires strict compliance. And just over the past several years, there has been a steady growth in the number of TCPA class actions that are filed. And with each year, more and more cases are being filed. Just already through October of this year, more TCPA lawsuits were filed in 2024 than in all of 2023. And I think we're going to see another uptick in 2025, and that's because of the FCC's new one-to-one consent rule, which you're going to hear about from Trey. So, as I said, there are 2 types of automated technologies that the TCPA regulates. And if a call uses either type of technology, the caller has to obtain the recipient's prior consent, meaning consent before the call is actually placed. And the first regulated technology is an auto dialer, an automatic telephone dialing system. What exactly is an auto dialer? Well, here's the language in the statute. An auto dialer is equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. It's a convoluted definition, as courts have recognized, not exactly a model of clarity. And because of that, historically, courts were all over the place in what an auto dialer really meant. For a long time, they had said that so long as the equipment, meaning the phone dialing system or software or platform, at least had the capacity to store or generate and call completely random phone numbers, a call using that system is a call using an auto dialer. That interpretation of the statute was extremely broad. And because so many of the modern dialing platforms out there do at least have this capacity, the interpretation encompassed a extremely wide range of calls and ultimately led to a lot of very large TCPA judgments. Now, fortunately, this interpretation, this broad interpretation, is no longer in favor, following a Supreme Court decision in 2021 that addressed a related issue under the statute. And without getting into too much detail, over the last few years, courts have said that a dialing system must not only have the capacity to generate random or sequential phone numbers, the call must use that feature in order for the call to be considered a call using an auto dialer. So in other words, if your dialing system generates totally random phone numbers and the system then calls those totally random phone numbers, you are using an auto dialer. But if the system only calls numbers that you previously collected and are in an internal customer database or internal customer list, you are not using an auto dialer to call them. This is an extremely important development and I think should bring a sigh of relief to a lot of educational institutions and other callers using dialing platforms. In my experience, most institutions are not cold calling completely random phone numbers. They are calling the numbers of people who have previously expressed interest in the school or its program. And so while the issue is not totally settled, it certainly is trending in the direction of the auto dialer definition being much, much narrower. That being said, as a precautionary measure, if you are using a dialing system or platform to place calls, as a best practice, I would still recommend that you assume it is an auto dialer and that you get prior consent. And that's because if there's ever a challenge to whether your dialing system is an auto dialer, you want to be able to argue right out of the gate that regardless of whether it's an auto dialer or not, you obtained the necessary prior consent. And again, we'll get into what that consent looks like in a little bit. So an auto dialer is one of the regulated technologies. And the other one is an artificial or pre-recorded voice. And so if a call is used, the call uses an artificial pre-recorded voice, you do need prior consent. What exactly is an artificial pre-recorded voice? Well, artificial voice is sort of what it sounds like. It's a voice that uses maybe AI or cloning technology. And a pre-recorded voice is also what it sounds like. It could be soundboard technology. It could be IVR technology or interactive voice response technology. And it also includes pre-recorded voicemails. The FTC, which also regulates calls using a pre-recorded voice, has made very clear that even if a live person, a live agent, is on the phone and they click a button to play a message with their own voice, if that message was previously recorded at any time, that still constitutes a call that uses a pre-recorded voice. So if you're using either an auto dialer or an artificial pre-recorded voice, you need the recipient's prior consent. And what that consent looks like exactly depends, as I said, on the purpose of the call and what is communicated during the call. If the call is a telemarketing call, meaning it is for marketing or advertising purposes, you need to collect prior express written consent. And so if you're a school, for example, and you want to call a prospective student lead about enrolling at your school, or if you want to call a current student about potentially enrolling in an advanced degree program, or if you want to call anybody else about some other good or service that you are offering, you need to collect prior express written consent if that call uses automated technology. Now, what exactly is prior express written consent? Well, it is a written agreement, and that agreement must do a few things. It must clearly authorize the call or text to be placed using an auto dialer or an artificial pre-recorded voice. The written agreement must include the signature of the person to be called. It must include the number that will be called or texted. And it must also contain clear and conspicuous disclosures informing the consumer that, among other things, he is not required to agree to receive calls or texts as a condition of purchasing the good or service. Now, this written agreement does not have to be signed on a piece of paper. The FCC and the courts have made very clear that this written agreement can be entered electronically with a consumer, such as through a text message, through an email, and importantly, through a website form. And website forms are generally the most common way in which this written agreement is entered. So we're going to focus on that today. But before we do that, I want to address a very important issue, and that relates to oral or verbal consent. The FCC has said that in addition to obtaining consent and entering into a written agreement through a web form or a text message or an email, consent can also be obtained in the form of a voice recording, so long as the oral consent satisfies the requirements of the federal e-sign Act. That language is somewhat misleading for a couple of reasons. So I really want to caution schools against thinking that they can rely on a recording of verbal consent provided over the phone as evidence of prior express written consent. And that's for a couple of reasons. First, you need to collect prior express written consent before you place a marketing call or text using automated technology. If you place an automated marketing call and collect the consumer's verbal consent during the call, in other words, you collect a voice recording, it's too late. You've already made that call. You cannot call someone using automated technology and then get their verbal consent to somehow retroactively authorize the call you've already placed, okay? So the only situation in which this would be allowed is if you place a marketing call not using automated technology, and during the call you collect verbal consent or a voice recording of consent. Now, second, and perhaps more importantly, as I mentioned, the FCC said that a voice recording can be valid prior express written consent so long as it complies with the federal e-sign Act. Well, what does the e-sign Act say? It says that a voice recording can count as somebody's electronic signature, such that a person can enter into a written agreement over the phone. All good. But here's the critical piece. The e-sign Act also says that if any law requires disclosures to be provided in writing, these disclosures still cannot be provided verbally over the phone, okay? They have to be provided in writing. Well, the TCPA, as I mentioned, requires certain disclosures be provided in writing. And that is exactly what a federal court addressed and held in a recent decision from June 2024 in a case called Bradley versus Dental Plans. It's a complicated case, but here's the critical holding from the opinion. The court said, the signature in TCPA consent the consumer provides can still be provided via voice recording, as can the substance of the TCPA agreement. The only portion of the agreement that would not be able to be provided via voice recording would be the TCPA's required disclosures. So, yes, you can collect consent and enter into a written agreement over the phone. But for that agreement to be valid, you still have to provide the disclosures to the consumer in writing, either via text, email, or some way else. And if that sounds confusing, it's because it is. Now, it's theoretically possible that you can break up the consent process to enter the agreement over the phone and simultaneously send the disclosures to somebody via text, email, and require them to acknowledge those disclosures. But as a practical matter, that will be very difficult to implement. It can be done, but you got to be very careful in how you set up your system here. And so for that reason, I would just highly advise anybody that is currently relying on a phone recording or verbal consent as evidence of prior express written consent to make sure that you're aware of all these nuances in the rules. Now, as for those written disclosures themselves, they have to be clear and conspicuous. Getting back to the web form example, it's not enough for these written disclosures to merely appear somewhere on the form. They have to be visible enough to put a consumer on a reasonable notice of their terms. It can't be buried on the web form in tiny font, and they definitely cannot be accessible only via a hyperlink. And ideally, those disclosures should appear above the button that a consumer must click to signify their consent. Now, yes, putting the disclosures above the button certainly makes it more likely that a consumer will actually read the disclosures and decide not to give their consent. Your lead conversion rate might go down, but by doing that, putting the disclosures above the button, you are protecting against the risk of a multi-million-dollar TCPA judgment because your disclosures weren't sufficiently clear and conspicuous. So just looking at the example web form here on the page, there are a couple things missing, and I just want to go over this. First, there is no disclosure in this language at the bottom that consent is not required as a condition of purchasing any goods or services. That language has to be in there. It's very clear under the FCC regulations. And second, there is no disclosure that calls may be placed using an artificial or pre-recorded voice. What if you're 100% confident that you're not using an artificial or pre-recorded voice? Should you still include that language? I would say yes. And the reason is because plaintiffs' lawyers are scouring the internet for web forms like this one that don't have that language. And even if you're ultimately not using an artificial pre-recorded voice or an auto dialer, and ultimately would win a lawsuit because of that, by not including this language in your web form, it at the very least increases the likelihood that you're going to get sued in the first place. And keep in mind, it's important to know that you won't be deemed to be actually have used a auto dialer or an artificial pre-recorded voice just because you say in your disclosure form that you will use one. There's no presumption of that. There has to be evidence of it, okay? Now, we've gone ahead and put together just a sample web form with the disclosure language. Again, this slide will be available to you, so you don't need to scroll it down. But it includes all the key language. It discloses that an auto dialer or an artificial pre-recorded voice message may be used. It discloses that consent is not required as a condition of purchase. It includes the phone number of the person to be called, and the disclosures appear above the agree button that signifies consent when clicked, all the text is in the same size, same color, and it also contains opt-out instructions, which I'm going to talk about later. Now, everything you just heard relates to consent requirements for automated marketing calls in text. But the TCPA also regulates informational calls and text that are sent using automated technology. And you still need consent here, but you don't need prior express written consent. You just need prior express consent. And the requirements for prior express consent are generally much more relaxed. The consent can be oral or it can be written. And essentially, if somebody provides you their phone number, you can call them using automated technology for any purpose closely related to why they provided you their number, as long as it's not for marketing purposes. So for example, if a student enrolls and provides you their phone number, you can send them automated calls and text for purposes related to their enrollment. For example, you can call them about their classes, their homework assignments, their tuition and fee charges, a school meeting, and so forth. But you just can't contact them using automated technology for marketing purposes unless you have that prior express written consent. Now, a word of caution, unless you have that prior express written consent, do not send them dual purpose messages. These are messages that include both a marketing component and an informational component, because those will be considered marketing messages requiring written consent. And so, for example, if you're texting a current student about a meeting where the school will be discussing advanced degree programs that students may want to enroll in, that would probably be considered a dual purpose message and require written consent. Ultimately, informational calls are rarely litigated because the volume of these types of calls is generally much lower, and the plaintiffs are less likely to be annoyed by these types of calls and interested in suing. But nonetheless, it is important to be aware of. And then finally, there is no consent needed at all to place automated emergency calls or texts. The FCC has made that very clear. One more important situation that I want to address before I hand it over to Trey. Let's assume that you are calling or texting someone for marketing purposes, but you are not using an auto dialer or an artificial or pre-recorded voice. For the most part, in that situation, you are in the clear. You can call any number for any purpose without getting any prior consent if you're not using automated technology. But there is one exception, and that is the National Do Not Call Registry rules, which are jointly enforced by the FTC and the FCC. And the National Do Not Call Registry is a website where consumers can register their phone numbers and request to not be contacted for marketing purposes. And every 30 days, if you are a company that is engaged in telemarketing in the United States, you are required to check the National Do Not Call Registry and add any new numbers on that registry to your own internal Do Not Call list. And if a number is on that National Do Not Call Registry, you cannot call them for marketing purposes, whether or not you are using automated technology forever. Now, of course, there are exceptions to this exception that would still allow you to call numbers on the National Do Not Call Registry for marketing purposes. And just quickly, the first exception is if there is a number on the list on the National Do Not Call Registry, and that number is associated with a person who later gives you prior express permission to contact them for marketing purposes, then yes, you can still call them for marketing purposes using automated technology. And then the other exception is the established business relationship exception. And an EBR can be formed in two ways. First, if the consumer was your paying customer within the last 18 months. And second, if the consumer inquired about your goods or services within the last 3 months prior to the call. Perhaps they called you. And so if the EBR exception applies, you can still call them for marketing purposes, but you just can't contact them for marketing purposes using automated technology. Okay? You would need to separately get prior express written consent to call them using automated technology for marketing purposes. So with that, I'm going to hand it over to Trey to talk about the one-to-one consent rule. First, I will let everybody know that it is time to select the first secret word on your screen. That secret word is mistletoe. So we'll give you about 20, 30 seconds to do that, and then I will hand it back to Trey.
All right, thank you, Brant. And again, before I change the screen, make sure you select B, mistletoe, for the secret word so you can receive the CLE credit. The information Brant just shared was a very good overview of some of the different difficulties in complying with the TCPA, and it is one of the more difficult rules to comply with. A lot of institutions do not do their marketing on their own. They rely on vendors to provide marketing and compliance with the TCPA. Now, if you do your own marketing, obviously the section Brant just covered is very, very important. But if you do not conduct your own marketing, this new rule that we're going to discuss, the one-on-one consent rule, that is going to become effective on January 27th in 2025. That is some 40 days away from now, is very important. And if you have not started implementing this rule, you are frankly behind. This rule is intended to close what is known as the lead generator loophole. You ask what that means. Like I just said, a lot of institutions rely on third-party vendors, also called lead generators, to recruit students and provide leads to institutions. And typically, these lead generators do not work for just one institution. They work for a litany of institutions, and when they obtain express written consent, as Brant just detailed, they do it on behalf of many institutions, not just one. And what is that? That's resulted in the FCC seeing a lot of students and consumers in other areas being contacted by a number of different institutions or other service providers that were not really anticipated by the consumer. So what the FCC has implemented is now the one-on-one consent rule. No longer can your lead generators provide a mass consent with dozens, if not hundreds of institutions, and then pass those down the chain to institutions and even other marketing providers. So that is coming to an end on January 27th. So if you use any vendors or lead generators in your business and recruiting students, you need to look into this rule very quickly. The FCC has said lead generated communications are a large percentage of unwanted calls and text and often rely on flimsy claims of consent to bombard customers with unwanted robocalls and robotext. The new rule requires one-to-one consent. And the best way to explain the change in rule is to show an example. The first example, and that is what most marketers are doing today, is going to be prohibited under the new rule. There will be a website, for example, could be, and this is fictitious, but findmydreamschool.com. And there a marketer could give information about all types of programs, medical schools, cosmetology institutes, culinary programs, trades, all types of different educations provided by different institutions. And what they do is they get one consent and they provide a hyperlink to a separate page and says, by marking this one consent, you also consent to being contacted by all these institutions. And they also generally list a lot of other marketing groups they'll sell that lead to. That, again, as I keep saying, is going to be prohibited in just 40 days. Now, if you use a lead generator, if they work for several institutions, that lead generator is going to have to list out each and every separate institution. So in the example below, it says, I agree to be contacted by each of these individual entities. And of course, I'm assuming that the lead generator has all the correct information that Brant's already discussed. But so Thompson Coburn Institute would be one. There would have to be an affirmative click of the box to get the written consent. Alabama Cosmetology School, affirmative individual consent mark. Phoenix Art Academy, again, its own individual consent mark. And this is a big change in the industry. And again, if you have not started working to come into compliance with this rule, you need to do so quickly. Additionally, this rule not only ends the mass consent, the chain consent, as I call it, and goes to one-on-one consent, it also requires that the consent be logically and topically related. A lot of third-party lead generators would use the promise of employment or employment information to get consent and then sell that consent to certain institutions. That is no longer applicable. So a consumer cannot believe that they are getting information to get a lead on a job or employment opportunities, and then that lead be sold to an educational institution. So the information being sold, it must be very clear that the consent is given because someone is wanting information about educational programs. Now, you may ask, well, if I use a third-party vendor and it's the third-party vendor who makes the mistake, as an institution, why would I care? Is that not their problem? The answer is no. The seller of the goods, in this case, the institution providing the education to students, is going to ultimately be responsible for the invalid consent. And courts, even before the new one-to-one consent rule, had routinely used vicarious liability to hold sellers and institutions responsible for invalid consents. There are three various types of vicarious liability that courts have upheld. The express agency relationship, that is a situation where an institution would have a direct contract with a third-party lead generator. Apparent authority, that would be where a student would see information about your institution from a vendor that would give the student the reasonable basis to believe that the vendor had the authority to act on behalf of your institution. And then ratification. Let's say you don't engage a telemarketer directly, but then someone contacts your institution and says, I'd like to sell you 100 pre-sorted leads that have consent. And if you pay money, you're then ratifying the actions of that vendor, and you can be held liable if the consent was not valid. Best practices here to protect yourself are two things. One, make sure your contracts with vendors are robust and have valid indemnification language, and that you're doing business with vendors that have the resources to pay if there is an indemnification claim. Additionally, you need to think about, certainly if you're doing your own marketing, you need to think about having TCPA insurance to cover the actions of your institution. And if you are contracting with a third-party vendor, you should either have that vendor obtain insurance on your behalf, or you should make sure that insurance that you have purchased will also provide coverage for mistakes by your vendors. So if you haven't looked at your insurance contracts or your contracts with your vendors, your third-party lead generators, now is the time to do that prior to January 27th. One thing to keep in mind about this January 27 effective date, clearly on and after that date, you must comply with that rule. But let's assume you got consent between now and January 26th. you can't then contact those students if the consent does not comply with the new one-on-one rule. So you can't rely on old consents that do not comply once January 27th occurs. So compliance should begin now, and you should seek the advice of counsel if you have any questions. Brant, back to you for the revocation of consent.
Yeah, thanks, Trey. And I know we're getting close to 1 hour here, so I'm going to just jump right into it. The other very important and new FCC rule that is going into effect in April 2025 is the FCC's revocation of consent rule. And that, you heard me earlier talk about the different types of consent that schools need to get before they can place automated calls or texts. If it's an automated marketing call or text, you got to get written consent. If it is an automated informational call or text, you need consent, but it can be verbal or written. And if you place an automated emergency call or text, you don't need to consent at all. Well, the FCC has come out with this new rule, and it says that even if consumers give their consent, we're making crystal clear that they can revoke their consent or opt out. This is not a particularly new concept. Consumers have always been able to opt out of receiving future automated calls or texts. But until now, there has never been a federal regulation that has codified this right to revoke consent. And the issue that the FCC is trying to address with this rule is that some companies have made it very difficult to revoke consent. For example, let's say you went on the Domino Pizza app, created an account, and you signed up to receive promotional. In the app says that you can opt out of future texts or calls, but only by sending Domino's a fax with your opt-out request. Well, a lot of people can't send a fax that easily. And the FCC said that requiring a caller to opt out or unsubscribe via fax materially diminishes the consumer's ability to revoke consent. And it's not just faxing. Under this new rule, companies cannot designate any one method as the exclusive method by which consumers can opt out. Okay, in the FCC's words, that places a significant obstacle on consumers who no longer wish to receive such calls. And so now, under this new rule, which is going to effect in April, callers must allow consumers to revoke their consent through any reasonable method, so long as they clearly express a desire to not receive further calls or texts. And certain methods are now going to be deemed per se reasonable and must be treated as an automatic opt-out request. The whole idea behind the rule is to make this process of opting out more uniform under the law. So what are these reasonable methods? Well, there's a few of them. First, a consumer can place a call, and if a live agent picks up, they can make their opt-out request to the agent. Second, if a consumer places a call and they are met on the other end by a automated or interactive voice, then they can opt out by responding verbally to a prompt or by entering a number on their phone. Third, consumers can revoke consent by visiting the caller's website and submitting a request to opt out. And then finally, consumers can opt out by sending a text message using certain words. And opting out via text message is really the focus of this new rule. And so there are now 7 words that, when texted by a consumer to the caller, constitute an automatic revocation of consent. And those 7 words are on your screen. They are stop, end, quit, revoke, opt out, cancel, and unsubscribe. And so this is all about making it easy for consumers to revoke their consent. Now, importantly, there is no requirement under this new rule that you actually tell consumers in your consent form language how they can opt out. But I would say that is really in a school's best interest to do this. You want to have a system in place for processing and recording opt-out requests, because ultimately that's going to reduce the risk that you accidentally fail to honor an opt-out request, which if that happens, it can turn into, of course, a very costly TCPA class action lawsuit. And so in that disclosure language, when you collect the initial consent, I would recommend that schools tell consumers how they can opt out. You can list a phone number where the consumer can call or text. You can also provide a link to a website where they can submit an opt-out request. What you can't do is not honor an opt-out request that is made through any of these reasonable methods. Now, what if someone texts something other than those 7 words I just mentioned? Well, it might not be an automatic opt-out, but you ultimately have to consider whether the language they used clearly expresses a desire to not receive further calls or texts. Now, how soon do you have to honor an opt-out request? Well, under the current rules, you have to stop contacting a consumer within 30 days. Under the new rule, you have to stop within 10 business days, and you have to put that number on your internal do not call list and not contact them for 5 years. As a matter of best practice, the FCC has said stop contacting them as soon as practical. Don't wait 10 business days. Now, the FCC's new rule also addresses the scope of an opt-out request. And this is really important because consumers often will give their consent to receive different categories of automated calls and texts, both marketing calls and texts and informational calls and texts. And so that sort of naturally leads to the question of whether an opt-out request applies to all automated calls and texts or just a subset of them. And there's some nuances in this rule, and so I want to walk through just a couple hypotheticals very quickly to sort of flesh this out. First, for example, let's say a school obtains a student's consent to place marketing calls and texts and informational calls and texts. And the school then sends the student a marketing text message. The student replies with a text message saying, stop. That is an automatic opt-out request. Does that mean that the school can still call that student using automated technology? No, it does not. The FCC was very clear. It said, when consent is revoked in any reasonable manner, that revocation extends to both robocalls and robotext, regardless of the medium used to communicate the revocation of consent. So, example 2. Let's say a school obtains consent to place marketing and informational calls and text. And the school then sends a marketing call or text to a student, and the student revokes consent to that marketing call or text. Can the school still place an informational call or text? Yes, it can. The FCC has said that an opt-out request only applies to robocalls and robotexts that the called party has received. And so if a student revokes consent in response to a automated marketing call or text, you can still send them automated calls or texts for informational purposes, such as about their class assignments or whatnot, just not automated marketing calls or texts. Now, let's flip that fact pattern. What if a student revokes consent in response to an automated informational call or text? Does that mean that school can still send automated marketing calls or texts? No, the FCC has said no, not in this situation. All further non-emergency robocalls and robotexts must stop. And the reason here is because the FCC is generally much more protective of consumers when it comes to marketing calls and texts versus informational ones, because marketing communications are just seen as much more invasive of an individual's privacy. And so it's going to treat an informational opt-out request much more broadly. Now, revoking consent to an informational call or text would still allow you to send emergency calls or texts via automated technology. The one exception would be, of course, if a student revokes consent in response to an emergency call or text, then those would have to stop as well. That's probably not going to happen very often, but it is just something to be aware of. Now, I have a couple more slides here. I'm not going to go through them because we don't have much time left. I'm going to pass over to Trey. He's going to talk about the FTC's record-keeping requirements rule. But just know that this new rule is going into effect April 11th, 2025. And so again, please reach out to your counsel to make sure that you're going to be in compliance. Trey?
Yeah, thanks, Brant. And I see we have several questions that have come in, so I'm gonna try to get through this portion quickly, because I think if you've got the PowerPoint, the list of new record-keeping requirements will be helpful, because you're not going to be able to remember them without having the list. But basically, there's two new rules under the FTC. One is simply extending the time period of the already required materials that you have to keep from 2 to 5 years. And importantly, if you're a school that uses vendors can keep the records that are required under this rule, but if they fail to do so, it'll be the school that holds liability. So again, make sure your contract with your vendor is clear and that they are actually keeping the required records. This new rule under 16 CFR 310.5A2, this is a new rule, and it's already in place. It came effective in October of 24. But these are the items that you have to keep for each and every call or text that is placed, right? And so this is new. This is a lot of information. Again, your vendor can keep this information, but make sure they are doing so. And if you haven't already started collecting this information, you're out of compliance with this rule. You need to do so quickly, and you've got to keep this information for 5 years. Now, I'm going to make sure the section above the list I just named, that each unique telemarketing script, brochure, advertising, promotional material, pre-recorded message used, that's already been a rule to keep those. It's now extended from 2 to 5 years. And again, it's not each script or each brochure, but each unique script or brochure and pre-recorded message and marketing material used. You've got to keep those for now 5 years. Additionally, for 5 years, you've got to record the consent obtained in the same format that you received the consent from a consumer, and you've got to keep that for 5 years. You've got to keep records of your Do Not Call list. You've got to keep the version of the Do Not Call Registry that you use for 5 years. And your contract with any vendors, you've got to keep that contract for 5 years, and not 5 years from the contractual date, but 5 years post any services that the vendor provided. All these rules are in effect. Some of them came into effect in May of 24. The new part with the litany of each individual call under that section A2 came in October. I'm going to quickly get through. In our slide deck, you'll see this. There's 3 slides we think provide a good summary. This, which details a little bit of the information and the effective date of what the different rules Brant and I covered. This slide provides the legal authority for the rules. And then on our Thompson Coburn Higher Education resource page, we have a 1-pager that provides a good bit of information that you can access quickly. And again, if you need an email of the slide deck, we're happy to provide that. We're going to move on to the last secret word. It is eggnog, number 1, and I'm sure everyone wants to be drinking eggnog after listening to a topic like the TCPA for an hour, but please take a few moments to log your answer. I believe we have 6 questions in the queue. We'll run a little bit over for those who want to stay and listen to our responses to these questions, but At this point, we're done with the presentation, so please log eggnog as your answer so you can receive your CLE credit. But we will stay on for just a few minutes and answer, I believe we got 6 questions. Maybe, no, I think we're up to like 11 questions, but we'll stay until we get them all answered. Okay, I'm going to roll into the questions, and I'll start and take them in the order that we received. The first question asks about a university has counseling services, and they offer to students. The students provide their phone number to the university. Can the university counselor use the auto texting information to, I presume, remind about the appointment? Yes. So this, again, you know, the devil's in the details on some of these fact patterns. I am not sure if the counseling services are free or if this is a paid service, but if the information given to the student is just informational, reminding about an appointment, that should be informational information and should not be subject to some of the TCPA requirements.
Yeah, I agree. I agree, Trey. You know, the only caveat there would be that you can't send marketing calls or texts that are automated for any reason unrelated to what to the appointment reminders and the counseling services.
Right. You couldn't solicit other type of counseling services. That would not be informational. So, all right. The next question: do schools need consent to send auto emails and text, or does this refer to voice calls? Under the TCPA, emails are not included. That's the CAN-SPAM Act, which is vastly different. You know, as long as you're not harassing people with emails, you can send emails without consent. Again, if you've got specific questions about the CAN-SPAM Act, you need to ask counsel. But text and voice calls are viewed the exact same under the TCPA. They are, you know, there could be some slight differences in the compliance, but you have to have express written consent if you're using an auto dialer technology to do either a voice or a text call.
Yeah, and that's right. And I would add that you do not need consent to send send an email for marketing purposes, but you do have to provide a mechanism to allow somebody to opt out of marketing emails. And that's regulated, again, yeah, by the CAN-SPAM Act and the FTC.
Right. And Brant, the next question I think is hit on the topic that you discussed about opt-out. Is it a statutory requirement that you include the mention of opt-out in a link in your call to your action consent language?
Yeah, I see that. Yeah, no, it is not a statutory requirement. I kind of thought it would be a statutory requirement, but it is not. It's more of a best practice sort of thing. The question asks, could you link generally to SMS terms and conditions that include those instructions? Yes, I do think that would be permissible under the new rule.
Right. And I think the reason we suggest to clients that you provide sort of clear opt-out is so that it helps institutions track the opt-outs. Because otherwise, if you get a random, you know, call or text message and you're not monitoring those opt-outs, you could miss those. So, okay, the next, if a consumer revokes consent, does it apply to all marketing types, email, or only calls and texts? I mean, Brant, I think you hit on some of this. I think it depends on what the revocation states.
Right. If a consumer revokes consent to a marketing call or text, then that revocation would extend just to marketing calls and texts. It would not extend to future marketing email communications. The one caveat there is that say a student emailed their revocation request to you. In that instance, I would err on the side of caution and honor that opt-out request as applying both to future call and text communications and email communications. But otherwise, if the revocation of consent request is just texted or called, it would not also apply to marketing emails. I hope I answered that right.
Yep, I agree. Next question, can you confirm that nonprofits do not have to be concerned about the do not call list, only their own internal list? Yes, that is correct. There's an exception to nonprofits. They do not, they're exempt from the national DNC list, but again, just be very clear that your nonprofit status is in effect if you're going to ignore the DNC list. Next question, do we get consent from leads we get in person at high school career fairs? I think it would be great to get the consent. You could have a form, get a student to sign, and you could have express written consent to contact them and add their contact information and then provide it to your marketing team. I think that would be a very good practice for institutions to use.
Yeah, but if there are people who come to a career fair or a high school and they just provide their name or number to you, that wouldn't in and of itself give prior express written consent to make automated marketing calls or texts. So
you would need to work with outside counsel or make sure that you have a form that's compliant for the student to sign and provide their consent. But I think that's a great practice for institutions to do. All right, finally, how does all this work with an individual referral? A student tells you about a friend who may be interested. Brand, I'll let you answer, but I'll say practically, if you're not using an auto dialer and you get a referral, you can certainly have someone in your marketing team physically dial that student's number and call them on the phone without express written consent. You just can't use automated technology or pre-recorded voices to do so. And you can then get that consent from the student and provide them with the disclosures and then maybe add them to your marketing automated technology.
Yeah, I agree completely.
Okay. Well, that is all the questions we have. I know we've run over a bit over time, but we thank you so much. There's a survey. We would really appreciate it if you let us know how we could improve or if you found this webinar helpful. And we look forward to providing another litigation roundtable webinar in the first quarter of 2025.